Thank you. Our next presenter is Michael Pena-Rees. Michael's going to address you in relation to tendency and coincidence evidence, and this is again an area where there's some quite substantial changes that have been brought about by the Act itself. Michael, again, is somebody who, on the face of it, appears to be fairly new in the practice of law, but when you go deeper into his background, it's not quite so. He signed the bar roll in May of 2008. Prior to that, he'd worked as a solicitor at Slades and Parsons and at Rob Meliseka's office, both of which are well-known criminal law firms, as I'm sure you're aware. But he has much greater experience than that brief introduction. He too was a police officer for many years. He was a police prosecutor and a detective in the Major Fraud Squad over some 20 years. He also worked as the Executive Coordinator Officer for the United Nations in Kosovo, involved in the reconstruction of Kosovo. Would you welcome Michael to talk to you on this, please?
Good morning, everyone. I hate to draw you away from the croissants and the coffee early, but this topic does have some breadth to it, and I probably won't be in a position to finish it. So I'm relying upon the notes that have been provided, and I must say I have to acknowledge from the outset that the notes, which some of you may have already have noticed, come from a fellow, John Stratton, Senior Counsel, who's the Deputy Public Defender for New South Wales. It comes from a website that I discovered in an unfortunate interlocutory appeal I was involved in earlier this year, where in Victoria there was no real basis to the new Evidence Act that we had. Most of the material was, or precedent material, was located in New South Wales, and this website, which is rightly called the Criminal Law Survival Kit, I located. It helped me immensely, and during that interlocutory appeal, I think it was the Queen against Darmody, I arrived at the court and with one folder and a printout of all the cases referred to by this learned fellow. The Crown turned up, who had been preparing for 12 months earlier, with 20 folders, 2 instructors, 2 juniors and a senior counsel. And it was a bit of a whitewash, but it was an experience, and experience for all of us, including the Court of Appeal. But let's turn to tendency and coincidence evidence. Most of you, in fact all of you, will know that this comes from what was previously known as similar fact evidence, a form of evidence that most prosecutors like to use when we didn't have much else in the case. A couple of famous cases, you may know them, you may not. Cases such as the Silver Gun Rapist. That was a fellow that would assault his victims in possession of a silver-coloured handgun. That was a famous similar fact case. Another one which is referred to in here is another sexual case, sexual offence case, relating to a fellow, I think it's a British case, a fellow that would dress up his victims in Indian headdress, and that became another important case in similar fact matters. So the evolution of that, as what we see today in the new Evidence Act, the act that's changed the landscape for most of us, to the point that I've heard that some of the judiciary are going to retire because they don't want to learn the new acts, and also maybe some counsel and solicitors, is this, that what it involves now is a far more technical application of what was the similar fact evidence. It relies upon the service of notices. It relies upon a particular legislative structure in the application of those types of evidence. Now, there's 2 words used there. There's tendency and coincidence. So that's also been divided in, and I'll go through that definition in a moment. In the material you have, you should have what I've located from the Supreme Court, which is their practice note number 4, 2010. And the last 2 pages, it's just a handy a notice that's been prepared as a pro forma relating to the application or notice that's required in the legislation that you may have come across already, either in the Magistrates Court, the County Court, or in the Supreme Court, or any other jurisdiction that relies upon this new codified system of similar fact evidence, where you can see that it outlines in very clear detail what's required. You fill in the blanks, and the blanks is what I endeavour to talk about this morning. So there's that material. That's just a helpful application of the notices and what's required in them. So firstly, we need to determine what is the difference between tendency and coincidence. On the face of it, you might not think there's much difference, and most of the time you get a notice covering both. You'll get a tendency and a coincidence in the one package. And you may get 4 tendency notices and 4 coincidence notices, all slight variations, watering down of what might be the main theme for the prosecution, watering it down to a point where they might see if they can get in very weak evidence involving those concepts. So tendency, and I've got in there an example of tendency evidence. This is on page 2 of it, halfway down the page. The pages might be numbered, your copies, mine aren't, so you might have the same thing I've got. An example of tendency evidence might be where the prosecution called evidence to show that an accused had sexually assaulted the complainant on a number of other occasions. And sometimes we do call it uncharged acts as well. Evidence of the character, reputation, conduct or tendency of a person is only admissible, and it goes on to say, well, the first point is what Stephen mentioned before, and that's section 55. So it has to be relevant. It has to overcome that point of relevance. So that's what you think of. When you get the notice, you look at it and you go, is it relevant? Well, yes, okay, it seems to be relevant, or it's not relevant. The next part that we move on to is, does it fall within the criteria for a tendency evidence under section 97? So in the Evidence Act, tendency has its own section, 97, coincidence is section 98. So you look at those aspects, but basically they both involve this significant probative value. That's not the threshold. That's just their starting point. So firstly, relevance, significant probative value for the Crown. I say the Crown, but and I might just add that defence can also serve notice as well. That's covered in here. You can have a look at that later. But it doesn't mean that we're excluded. If there's some reason why you need to get tendency evidence in relation to another witness or another aspect of your case, it doesn't exclude defence. So section 97, I'm not going to read section 97, you can have a look at that, but the important part is that it has significant probative value. The threshold test that's required in the legislation is contained at section 101 of the Evidence Act, and you can read there that where the evidence is tendered by the prosecution in a criminal trial to be admissible to the probative value of the evidence, it must substantially outweigh the prejudice to the accused. So that's what the end result will be. That's what the end test needs to be for a magistrate, judge, justice to determine in your application. So, and as you can see, I've also given this a general context of what tendency and coincidence can be at that list there. So, in terms of tendency, it might be something of this nature that you might say that, he has a tendency to perform in this particular way. For instance, and there's a case I'm going to refer to. I'll refer to it now. You might want to write this case down. It's an interesting case, and it covers both coincidency and tendency. The media neutral citation for this is GBF against the Queen, 2010, Victorian Supreme Court of Appeal, 135, and the date is the 7th of June 2010. The judges are Nettle, Harper and Hanson. And in that case, and I'll refer to it quickly in a moment, a bit later, is that what you might have is in relation to the tendency in that one, that case involved a person who worked in a hotel, I think it was the Currumborough Hotel, or one of them up there, and he had a history of indecently assaulting or touching inappropriately bar staff over many years. I think it was about 10 or 15 years. And the tendency was that he had this behaviour, this was his behaviour. He did it all the time to these different barmaids over many years. So that's tendency. He has a tendency to perform in a certain way or do a particular action or speak in a particular way, anything that shows some tendency to that individual. The coincidence was, because in that case you'll see they also use coincidence in there, relating to, the coincidence was he just happened to touch that one, they gave evidence in the same way, touched them on the breasts or wherever it was. But you'll read all about that in that case if you get time. It's not lengthy. And that's one of those cases that they had served, that's the Crown had served, 4 notices of tendency, 4 notices of coincidence. Each of them slightly watered down from a main platform to a very weak position. The interesting aspect about that case and what was determined is that the whole notices involving both coincidence and tendency were rearranged by their honours, and a number of the aspects that the Crown sought to rely upon for both coincidence and tendency were removed, disallowed. So just because you get a tendency notice and you think you might be, you argue it at court somewhere, it doesn't mean that necessarily you can't appeal it, because it seems from some of the cases I've read that on appeal it does have this rearrangement or realignment in terms of what is the essential aspects relating to both the relevant Section 97 and the threshold of 101, Section 101. So a good case to have a look at. I think the original judge in that one was Judge Pullen from the County Court. And then we go on, this must be page, I think it's 3 now. The material that's been supplied to you in relation to this topic, you probably would have received a message from my clerk that it'll be emailed to you in electronic format with the hyperlinks in it, so you can click on those cases that are relevant and download them and print them out and use them as you see fit. It goes on page 3. I'm reading what the term significant is. The significant probative value. This is paragraph 2. And it's said that it has to mean something of the form of important or of consequence. And then it goes on in paragraph 3, the requirement that the probative value of the evidence must be substantially outweigh the probative value of the evidence under Section 101 of the Act is higher than the requirement 97, because that's not the threshold. 97 is the first step that whoever is taking that notice before the court must reach as a test. Then the threshold as to whether it is admissible and gets through is 101. It then moves on to the coincidence rule. And the coincidence there, it gives an example. An example of this is that 2 bank robberies or sexual assaults of different complainants were so similar that it was unlikely that they were committed by different offenders. Again, such as the case of the silver gun rapist. That was the link between the two. It was so strikingly similar. And you probably heard me use that word strikingly. We'll talk about that in a moment. That's the old term, and it still applies today, I think, but we'll talk about that. Strikingly similar in that the gun was unique to that particular offender, and nobody else seemed to be carrying a silver small handgun when they were committing these types of offences. The coincidence evidence is that 2 or more related events occurred to prove that because of the improbability of them occurring coincidentally, that a person did a particular act or had a particular state of mind. Such evidence is only admissible if, and then we go through this testing stage to the threshold level again. So firstly, section 55, is it relevant? Does it have significant probative value under section 98? And does it meet the threshold test contained in section 101 of the Evidence Act, and that is that the value of the evidence must substantially outweigh the prejudice to the accused. And I've gone on there to say two or more events, well, I haven't plagiarised this material, I suppose, but I've acknowledged it, so I won't get in trouble, hopefully. Two or more events are to be taken to be related if and only if they are substantially and relevantly similar, so substantially and relevantly similar, and have significant probative value. So, for instance, in the silver gun rapist, I'm using a very basic example, not because I'm undermining your intelligence, it's because I'm trying to deal with my own intelligence on this topic, and that is if, for instance, that person had a number of guns and they were all different over a series of time, not silver, not a handgun, then the relevance and that similarity would be reduced. The likelihood is it wouldn't be something in this new legislation that could be put on notice as a notice of coincidence, so it wouldn't be admissible. Now, and it also have to have that significant probative value, so, and that's a common theme in this Act as well, the probative value aspect. So the next part is you've received the notice, we hope, because there are going to be many times when you probably haven't received the notice. And they say, oh, we intend to seek to rely upon tendency and we're going to serve the notice today. You know, on the day, the door of the court on the day of the trial. Now, as much as that might be troublesome to you if you're running your defence or if you're the prosecutor and the defence are giving you the same sort of notice, either in tendency or coincidence format, the Act does have the provision and the ability to provide for a setting aside of the requirement, and that's under section 100. And basically the criteria for that is not very high, I must say. So, and that's also the same for the notice for unavailable witness, which Stephen spoke about. I had the same thing in that case. I did. There was no notice served, and there is that discretionary ability to set aside the requirement for notice. So don't rely upon the fact that you can go into a full argument about, well, they didn't serve notice, so it's bad luck. It's too late. They can't get it in because section 100. I'm not going to go through it. But have a look at section 100 before you start going down that path and see whether or not it's going to assist you or not. But the notice, and I won't go through that either, because as you can see in the Supreme Court pro forma document, as to both tendency and coincidence outlines what's effectively in that material you've got. So it has to be fairly comprehensive without being the total evidence, of course, but it has to cover the important aspects of why the Crown, in this instance I'm talking, might be saying why that coincidental evidence should be admitted. The person who's going to say it, why they're saying it, on what basis, it's fairly straightforward. And the requirements are located under got it to section 7 because that's how it came up, but it's in the regulations. So the evidence regulations 2009, I've got a copy here, and that outlines exactly what's required for both notices. So you can't go wrong if you look at all these various sections. They're all interlinked, and once you follow them, you should get some indication of where you're at. And it says here, general notice such as, this is at the unnumbered pages, page 5, the top of the page where it starts, section 7, evidence regulations 2009. A general notice such as in the case in respect of each complaint, the Crown will lead evidence of the charges in respect of each of the other complaints is insufficient. So it has to have some detail in it. It just can't be a very general document that passes off as an illustration of what they're endeavouring to have put before the court on the basis of coincidence or tendency evidence. And there's a case referred to there. Goes on to say, a failure to object to the lack of notice cannot constitute a waiver unless the court is satisfied that the accused had his rights explained to him and that he understood that explanation. So just because you don't object, obviously it's a matter for your client, who has the say as to whether or not he would have objected if he had known about it, I suppose. Now we move on to the next part. It says tendency, coincidence, evidence exceptional. And it says to be admissible it must be such that it would be an affront to common sense to exclude it. There's a 1978 case there. So the more general the tendency relied upon, the less likely it is to have sufficient probative value. I won't go to the next page. That talks about the threshold test. That's something you can read in your own time because otherwise we'll be here all day. Moving on to the next page, the top, it talks about strikingly similar. And it refers to a number of cases down below that continues on. And then the next page where it has the proper title of strikingly similar, I'll just mention something about that. The heading is strikingly similar. Where the identity of the perpetrator is an issue, there will usually need to be a striking similarity between the similar facts and the offence alleged in order to have the sufficient degree of probative force. In Fenwick's case mentioned, the similar facts will not be admissible if they are commonplace or part of the stock and trade of persons who commit offences. And in that case it would be, for instance, an example of a person commits a number of burglaries and basically they use a jemmy and they always open up the side window of the house. Well, most burglars, if they open up a window of the house, and sometimes most of them might have a jemmy bar or screwdriver of some sorts. So it's too general. An example of a very specific type of strikingly similar is a burglar who, before he enters or breaks into a place, in particular shops, goes down the manhole out the front of a shop and disconnects all the electrical wiring to disable the alarm system. And he's done that in the past, and all the burglaries we've had here are all the same. They're all disabling the alarm system by going down the manhole out in the street. Now that might have some striking similarity to it. So that might be far more on point than a very general statement. So that's important. And they've given an example here, and I don't know about the burglar example that Mr. Stratton's used, but he said a burglar goes through a ground floor window. The rule will not apply, but if the burglar leaves an esoteric symbol painted in lipstick on the mirror, I think that with that burglar we've got some problems if he's carrying lipstick around with him, but it's still strikingly similar. It's just a very odd example. It must be a true case, obviously. And they've mentioned the Indian headdress case, a famous case, Boardman. Yes, Boardman. So one interesting thing that was mentioned earlier is that a lot of people seem to have this belief that tendency and coincidence evidence only relates to sex offences. And where this will impact on us is that I think this will be being used more and more in outside of the square thinking process. So they'll be using it in relation to financial matters possibly of fraud or business dealings, or matters whereby there is other aspects of offending that we are not commonly referred to using this type of similar fact or tendency coincidence. And an example, I suppose another example I can talk about is a drug importation case that I've just been doing, is that the tendency and coincidence evidence that was supplied, the notices supplied, related to previous dealings with other participants in relation to the use of couriers to bring in, I think it's cocaine, into Australia. And unfortunately that's not really strikingly similar, but it was sought to be relied upon. It was subsequently withdrawn, the notices, because effectively what they would be doing is by supplying those notices and relying upon those notices, if it was found that any of those tendency or coincidence evidence was dismissed or not sought to be used by the jury, then they didn't have much left. It was a conspiracy case, so that's the reasoning behind it. So it was dismissed. So it can be used in a number of matters, and I'm sure in fraud matters it's going to be used more extensively with people and how they commit particular fraudulent activity. Move on to a next page, which should be single complainant, multiple complainants, possibility of concoction. I'm not going to talk about that. Evidence of prior acquittals. Yes. And it's got here that interesting fact that evidence of matters of which the accused has been acquitted may not be led by the Crown as similar fact evidence. And then it mentions the approach has not been followed by the House of Lords. It's got a case there. But there's also Section 91 of the Evidence Act, which has an exclusion about prior hearings and the results of prior hearings, and that is a mandatory exclusion. You're not going to get it in. You just won't get it in. So I've got the next page there is the proofs. I won't go into those. I'll go to the section there. It says discretion, and under discretion you'll see that it says even if the similar fact evidence is admitted under Section 97, 98, and the threshold is reached in each under Section 101, it appears that there is no room for the court to reject the evidence in the exercise of its discretion under Section 135 and 137. So those discretionary exclusionary sections in the Act, which we have probably already come across and probably already applied or put forth in submissions in various cases, from what has been determined here in the case there, Regina against, I can't say that name, Nagatakura, I think that's right, would seem to say that that is the position. So you don't get the second bite of the cherry to get rid of the evidence. I'll finish on that note there, and again I'll just refer you to that case of GBF against the Queen 2010. And inside that case, it is very eloquently put by their honours that the definition of tendency, coincidence, the definition or the application of significantly probative in issue, and the interesting part about that is how that they go about the process of eliminating the various aspects of coincidence sought to be relied upon by the Crown and the tendency. And it's almost like a formulation. They go through it in a matrix style, eliminating certain aspects, referring it back with this new revised areas of tendency and coincidence that can be relied upon on a retrial. So an important case, I think. It's probably the most current in terms of Victorian in this state. So an interesting aspect that needs to be looked at. You're going to come across it, and I think that's it. I think I'm finished there. Thank you.
There's time, if anybody's got some questions, there's time for just one or two very brief questions if people have questions. I'm sure both our presenters will be happy to give you whatever they can. Has anybody got any questions they'd like to ask? Yes.
Just the issue on 65.3, just reasonable opportunity. You have a committal and you nominate 3 out of 10 witnesses to cross-examine. You don't touch the other 7. One of the other 7 is magically not available for a trial. You have a reasonable opportunity. As opposed to a situation where you don't elect to have a committal rule.
Sorry, you're referring to the witnesses being called, you just didn't really have a go at them?
No, you've only called the 3 out of 10 because you wanted to leave the other, for various reasons, you wanted to leave the other 7 alone.
If you've left the witness alone, you didn't call them for cross-examination, and they've just gone through as part of the balance of the hand-up route. Look, I think the Crown could possibly argue that you had a chance at it, but I think there's been some decisions in the Court of Appeal in Victoria on that point, and it has been considered that you've got to be given the opportunity to have a bit of a go at them. And I think in circumstances where you made that forensic decision to not cross-examine them, that's probably one of the ones you wouldn't be tripped up on. It's where the witness was called and for whatever reason you chose to not take them to a particular topic or challenge them on a particular area of their evidence. I think that's where there's that danger. So it's a matter of really doing the committal properly rather than just letting it go through straight hand up. I think that's probably how the court is seen.
Yeah, it just seems to me that there could be that argument that if you've made that decision, a forensic decision, not to, that you have had a reasonable opportunity. If you've run a committal, if you've run a contested committal and made the decision not to, how is that different from, I'm only just, in a sense, running the argument in my head, how is that decision different from calling the witness, only cross-examining on certain parts and not going to the others? Again, for the same decision, I'm just wondering, because that can be a real trap.
I can't think of a case specifically, although I know that issue has been looked at, and it's been probably dealt with in a way that favours the defence, where the opportunity to cross-examine has to have been a genuine opportunity
And exercised.
And exercised, yeah.
Yes.
Any other questions? Okay. Can I just say thank you very much to both Steve and Michael for their presentation. I've certainly found it very valuable. You've got lengthy papers which I'm sure will assist you once you leave here. I must say I think they've both been very ambitious in trying to cover in 30 minutes the areas they have, because as you can see there are some major changes that have been brought about. Let me just identify one other which was never intended to be touched upon today, but if you look at section 85 of the new section 85 of the New Evidence Act, you'll see that in criminal proceedings the concentration is no longer on whether or not a confession is voluntary. Of course, we've got all the restrictions on how one can interview a suspect, but the old cases in the High Court of McDermott and Cornelius, which say that a confession must be voluntary in the sense of an exercise of free will to speak or remain silent, no longer apply, because the emphasis is not now on the voluntariness, but whether or not the admissions that have been obtained are likely to be reliable. You might still be able to get it out under 138, unlawfully or improperly obtained. So forget what it was at common law when you go to court. Please think and have a good look at the new Act before you go and try and work out how you can get evidence in or keep it out. But can I just, on your behalf, say thank you very much to both Michael and Steve, because I think their papers have been fantastic, and if we could give them the usual thanks. Thanks very much, folks. And thank you all very much for attending.